Good afternoon, and today is Tuesday, January 12th. Live from Washington, D.C., Venable LLP welcomes you to our webinar, Consumer Financial Protection Bureau Outlook 2016. My name is Jonathan Pompan, and I will be the moderator for today's webinar and one of your panelists. I'm a partner and the co-chair of the CFPB Task Force here at Venable, and for about the next 1.5 hours, members of Venable's CFPB Task Force will review the current state of federal consumer financial protection law and policy and outline what you and your company or organization need to know about what's ahead. During the webinar, our panelists will share their experiences from the front lines and offer strategies to help you navigate the evolving legal landscape. Our webinar today will be recorded and downloadable, and slides will be available later this week too. Today's webinar will be a roundtable discussion, and that's right, rather than have this be a series of lectures or individual topics that will cover information in a micro manner. Rather, what we're going to do is we're going to be discussing each of the topics in the context of both what in-house counsel need to know and where the CFPB is headed. Please follow the on-screen prompts for submitting questions, and I'll do my best to incorporate them into our discussion and remind you periodically of the opportunity to ask questions of our all-star panel. CLE will also be offered today, and for those of you who receive or need CLE credit, there's going to be a code at the end of today's session. Please stand by for that code. We'll be providing that in about 1.5 hours. And of course, there'll be an email sent with all the pertinent information related to the CLE offering after the webinar, either later today or later this week. So advertising or providing or offering consumer financial products or services such as a loan or taking payments, furnishing data to consumer reporting agencies, or collecting debts all are covered by the CFPB. And you're likely asking yourself, what's next on the legal horizon? With 2016 now upon us, consumer financial services providers are taking a good look back and a look forward to plan for the year. And we've got you covered today when it comes time to assessing the legal and regulatory landscape with today's webinar. The legal and regulatory changes expected in 2016 may affect your clients and the focus of your internal compliance and audit teams. However, it's worth noting that the areas that the CFPB and other regulators in the consumer financial services space will be focusing on this year include several that have already been subject to enforcement or supervision priorities of the CFPB or other agencies and will be relevant for consumer-facing companies. So we'll make reference to those as well today. So now let's meet our all-star panelists and get everyone moving forward on today's presentation. So first up, today's discussion is going to be on a number of different topics and areas, and those areas are going to be covered in a manner in which we'll have a discussion. So as folks have comments or feedback, please share those. And members of the audience that are listening today, please feel free to, again, email your comments in by following the on-screen prompts. So first up, Alexandra McGarris.
Good afternoon. Thanks, everyone, for joining us.
Alex, you provide legal and regulatory counsel to financial institutions, including advertisers and lead generators, debt buyers and collectors, and lenders on a variety of compliance and consumer finance matters. Now, what are you seeing from your work here on the front lines?
So with 4 years under its belt and ever-increasing staffing, budgeting resources, I think many would say that the Bureau has, with some exceptions, hit its stride. And taking just a step back, whether it's rulemaking, preparing for an examination, appealing findings of exams, or investigations, I've kind of noticed a bunch of trends and tips that I'll share throughout this presentation, but kind of two major themes. First, as we will cover in this presentation, the Bureau has hit some snags in its regulatory agenda. Many of its rulemakings continually get pushed farther and farther into the future. And in the vacuum, we see enforcement increasingly step up and arguably regulate through enforcement action. And we'll cover a couple of those areas. Debt collection comes to mind. And the second kind of theme that we're seeing increasingly companies pushing back. We're seeing more litigation than just consent orders and settlements between the CFPB and parties, and also companies filing their own lawsuits and pushing back in both the exam context and in the enforcement context.
Thanks, Alex. And that brings us then to Allison Baker. Allison, You're the co-chair of the firm's CFPB task force and joined Venable after working at DOJ and in the Office of Enforcement. What are you seeing in 2015, and what are you predicting for 2016?
Good afternoon, and thank you for that lovely introduction, Jonathan. What I saw in 2015 and what I suspect will continue well into 16 and beyond is a very much more aggressive enforcement office, an office that is committed to taking cases to court more frequently, to pursuing civil investigative demands in court as necessary, to taking pretty assertive positions in both investigations and litigation. And I think we'll continue to see that. I think we'll also continue to see the Bureau's interest in pursuing and expanding its own enforcement jurisdiction through various cases that it brings. I think we saw that in 14 and 15, and I have no doubt that some of the disposition of those matters will come about in 16.
Andy Arculin, in spring 2015, you joined our group from the CFPB's Office of Regulation. You had a close-up view of rulemakings, and now that the mortgage ones are over, there are others that are in the hopper or on the way that are going to be priorities and also areas of interest for associations and, of course, companies in the consumer financial space. What are you seeing?
Well, I'm seeing a number of things. First off, I wouldn't say the mortgage rules are necessarily out of the way. There's the TILA-RESPA integrated disclosures rulemaking, which we'll talk about, continues to be a hot topic. That's a really big area for compliance. There's a new HMDA reporting rulemaking that the CFPB is now in the implementation phase for, meaning they've issued a final rule, and now it's upon the industry to get compliant and the CFPB to build a reporting database and procedures. The CFPB's also expanded their horizons. A lot of the work that I did was in mortgages when I was at the Bureau. The initial rulemakings were primarily under the Dodd-Frank Act. Then there are other rulemakings like the integrated disclosures. What the CFPB is moved towards is discretionary rulemakings. We'll talk in a bit about a rule for payday lending and title loans. That's an area where the Bureau isn't necessarily operating under a statutory mandate, but they've decided that they want to make a rule about certain financial products. They've been working for some time on a debt collection rule, which Alex mentioned has hit a few snags and been delayed in terms of when they're actually going to roll it out, but that's in the works. There's an arbitration rulemaking, which is about mandatory arbitration clauses with class action waivers that we'll discuss too. The Bureau is doing a number of things on the regulatory front and continuing to support all of the rules that they've already rolled out. So I would say that the main takeaway is they have shown no intention of pumping the brakes. They are still going full throttle and issuing rule after rule.
Yeah, and after 4 years, they've really, as Alex mentioned earlier, sort of hit their stride. And now that they've sort of are hitting on all cylinders, rulemaking being a big part of it. Andrew Biggert, you manage compliance reviews, investigations, exam prep, and exam appeals. In your practice, compliance is a big part of it. What are you seeing now that there is a lot of word on the street about what the CFPB's priorities are? And certainly, for instance, the complaint portal is a good example of where the CFPB is generating a record of what consumers think may be wrong in the consumer financial space.
Yeah, thank you, Jonathan. I think what we've been seeing a lot of, and kind of represented by the complaint portal, is that the CFPB expects industry to be proactive, not just reactive in terms of when it comes to compliance. It's not necessarily enough to just understand what the law is or how it may apply to your company, but if you're an in-house counsel, if you're a compliance officer at a company, to really understand the consumer implications of your operations, your practices, your procedures. The complaint portal here gives you an example of how any consumer can write in and submit a complaint, and that puts the pressure on companies to really understand the day-to-day operations of what they're doing, and that's the kind of thing that we try to help them with when it comes to either doing exam prep or once we're working with companies within an examination, is understanding both the big picture but also the details that the examiners and the CFPB will focus on.
Yeah, and we'll see that in our markets discussion in a little bit. Len Gordon is a partner and former head of the FTC's Northeast Regional Bureau in New York City. Len, you've seen regulatory agencies from the inside out, leading the New York City office of the FTC. And of course, the FTC is a bit of a model for the CFPB, but the CFPB is not exactly the same. What are you seeing now, now that 2015 is behind us and where we're headed for 2016?
Thank you, Jonathan. A couple of things. First off, I think there's a little bit of rivalry between the two agencies to show who's the toughest kid on the block. And obviously the companies that are the fodder for the two agencies in that competition clearly suffer. I think each agency is trying to show that it's the toughest law enforcer. The biggest difference that I see between the two agencies is the FTC has a pretty well-established process if you're let's call them a legitimate company, not sort of an out-and-out fraudster, that you go through before you get sued, and you've got lots of opportunities to work the bureaucracy up and down to try and resolve the case, change the case. My experience and observations with the CFPB that it's much more opaque. The bureaucracy, perhaps because it's not been as in place for quite so long, the procedure is not as clear, and I think companies are much more frequently surprised at sort of where the CFPB lands, including not finding out that enforcement action is going to happen until they've actually been sued. So I think that's the biggest difference in my observation.
Thanks, Len. And whether it's leading compliance investigations or enforcement matters for any number of markets, including companies in the debt buying and collection industry, money services business, debt relief companies, advertisers and marketers that are looking to partner with consumer financial products or services providers, as well as also, of course, folks that are developing new products and services, such as folks in the marketplace lending sector. Increasingly what we're seeing is a need, if not only to predict where the CFPB may be landing on a particular issue, and that's certainly influenced by what the Consumer Complaint Portal and other areas are showing, but also this need to sometimes push back a bit. And I think that we're hearing that from all of you are saying that today in one way or another, that after 4 years, we're seeing more need to push back on areas where either there's a need for additional education or legal analysis and misunderstanding of the facts, whether that be in the supervision or examination context, as well as also in investigations. And then, Andy, even in the rulemaking context, the need to have folks be educated and really understand the market and what the history of the law is really important.
No, that's absolutely right, and you'd be surprised how many hot-button issues are issues where the Bureau never received comment. It's important, really, to pay attention to the proposals, to give the Bureau your feedback. They're obligated to consider it. They don't have to necessarily take your recommendations, but they are obligated to consider it, and it's a good way to educate them and make sure that something doesn't happen with consequences down the road.
Right, and building the record is just extremely important.
Absolutely.
So, the CFPB's work in understanding issues in the consumer financial marketplace and in helping the market work better for consumers, in their view, is influenced by a number of factors, including the complaint portal, which we just saw some statistics on. You've got situations where, for instance, debt collections, leading the pack in terms of financial remediation, but also in the number of complaints historically with the FTC and the CFPB. And that's usually the case in part because virtually all consumer financial products and service providers do some form or need some form of debt collection because of accounts receivable situations. But up and down the line, depending on what the market is, that is influencing heavily the rulemaking areas. There's also, of course, feedback that they're getting directly from their marketplace observations through supervision and examination, and then some targeted exams and investigations as well. But there was also, Andy, some statutory required work that the CFPB has had to do under Dodd-Frank that you were a big part of, the mortgage rulemakings. And those mortgage rulemakings essentially came to a head in 2015, and now you've got a scenario where folks are in the process of implementing these rules. So why don't you walk us through a bit what those major events are and where they're headed?
Well, the major events for mortgages in 2015, as you can see on the slide, the big one really was I mentioned this before, the TILA-RESPA integrated disclosures. TRID is what everyone's come to know it as in the industry. Rich Cordray, by the way, hates that word. He has said publicly that it's dirt spelled backwards. So you'll also hear the CFPB call it the know before you owe rulemaking. It's basically what this is a new disclosure regime, but it's a lot more than that. It's 2 new disclosure forms that you get when you apply for a loan and when you close a loan. but it's an integration of two different statutory regimes. It's incredibly complicated. It essentially was a rewrite of the entire origination system. That has now taken effect. The world is trying its best to comply with TRID, in some cases successfully, in some cases not so successfully. There are a lot of difficult issues, and getting ready for both examinations, investor diligence, and potential lawsuits. Another big issue for 2015 was scrutiny of marketing services agreements, or MSAs. These basically fall under RESPA, the Real Estate Settlement Procedures Act, which has an anti-kickback provision. And there was just some skepticism from the Bureau initially about whether an agreement for a co-settlement service provider, like a title company, paying a realtor to do marketing services would constitute a kickback if they're getting business in return. There's written guidance issued, as well as some enforcement activity. And then, the big event looking forward is a new reporting rule under the Home Mortgage Disclosure Act, or HMDA. That actually was just finalized in October. The implementation phase is going to be phased in over the next couple of years, with some concerns about privacy and fair lending that we'll discuss.
And Andy, the HMDA rulemaking, which is on its way in terms of the work that folks in the industry need to do, folks in the mortgage industry and the service provider industry have already been undertaking some massive changes because of the TILA-RESPA integrated disclosure rule. So there's some suggestion, including by some trade associations, including a letter that was written today to the CFPB that was publicly available, that the HMDA rulemaking is essentially, it's a double whammy. If folks have just or are still in process of rejiggering all of their systems for the compliance with TILA-RESPA, and then they're going to have to do the same thing essentially all over again for the compliance burdens of HMDA.
And this is not a new concept. The same thing happened when the TRID rules were finalized in 2013, and everyone in the industry was still trying to get their head around the Title 14 mortgage rules. They really have been one on top of the other. The Bureau's response to that is that they're giving a lot of time for implementation of HMDA. It's phased in between, over the next 5 years, essentially. So there isn't a rule that everyone has to comply with and start reporting under next year, but certain components of it will take effect next year. And really the concerns that are out there are about privacy and fair lending concerns, if they're reporting these sensitive data points, and if they're reporting loan pricing that the Bureau can see and the Bureau can scrutinize.
Right. So the TILA-RESPA integrated disclosure rule, been in the works for a while, stems from Dodd-Frank, but also there's a lot of themes in here that are going to be carried over in other rulemakings because of either the concepts such as disclosures and the way forms are put together, what needs to be disclosed versus what can't be done at all, as well as also its influence because a lot of the folks, your former colleagues in the Office of Rulemaking, have now in some cases moved on or doing double duty in other rulemakings. So why don't you walk us through quickly TILA-RESPA?
So TILA-RESPA, as I mentioned before, is essentially a redo of the entire mortgage origination system. It affects every aspect of a mortgage transaction, from the application to the initial disclosures to the final disclosures to the closing. There's an integration of two different statutory regimes. One, TILA. TILA disclosures are something most people who do any sort of lending have seen. RESPA had the GFE, the good faith estimate, and the HUD-1. Those have now been integrated with the TILA disclosures into two very complicated forms. As we were discussing before, the real challenges now are, the Bureau has unleashed this beast of a rulemaking. It was around 2,000 pages. It's very complicated. It's very technical. A lot of the disclosures, there really is, you have to be 100% right or you're 100% wrong. And there's a lot of different competing interpretations, arguments over what the rules require and what they don't, and especially confusion over different types of transactions that weren't necessarily tested for the new disclosures. A good example would be construction to permanent loans, or even something very common like FHA loans, where the Bureau tested these with consumers. They tested them with very conventional loan products, and they don't always necessarily work. Part of what I do with my clients regularly is resolve these discrepancies between investors and lenders, between settlement agents and lenders, between brokers and lenders. and often, you have to go to the agency and get them to bless or agree with guidance. Those are all remain challenges. Liability, I know Allison and I have talked about this a lot. Liability is another big hurdle that will have to be jumped over next year. The CFPB recently issued a letter to David Stevens of the NBA that all but downplayed TILA liability. I think there were some issues with the letter that, for one, the agency can't really say where liability lies, and it doesn't. That's really between Congress and the courts, and may depend on individual facts. They also made some statements about certain disclosures not being subject to statutory damages that may be, and those will all be issues that everyone grapples with as we move on, especially as we get into a world where the CFPB is examining for technical compliance.
And that may actually be the case too with future rulemakings in terms of the transition periods, that the precedent set now with respect to transitions from one set of law to the new rules, whether they're technical or not, whether they require a lot of overhaul of internal systems of record or simply just business practices, how the liability plays out for the time period during what ostensibly is a pretty rough transition for some companies is going to be important, and that's going to be the case not just here, but also in debt collection and many of the other rulemakings too.
Sure. Especially where there's new rules under new statutory provisions and it's not necessarily clear where liability lies and doesn't. Sometimes there are private rights of action, and for other provisions there aren't.
Hey, Andy, turning to the next slide here, could you spend a little time giving us some insight on how the Bureau views MSAs and kind of some of the guidance that they've provided there?
Sure.
It's really a topic that's really of interest to advertisers and marketers who work with mortgage companies too, because there's obviously two parties to an MSA.
Right. So the history behind MSAs, just to give it at a very high level, these are agreements commonly between title companies or lenders or other providers and a different party, whether it's a realtor or a title company or a lender. And what these are, they're basically agreements to market through someone that potential customers are doing business with already. The most common one, and the Lighthouse Title decision is referenced here, that was really where this started. It was in 2014. There was an agreement between Lighthouse Title, a title company, and realtors for the realtors to market title services. Well, going back to the pre-CFPB days, HUD had, at least implicitly, they had issued some written guidance that, gave people in the industry who wanted to do these sorts of arrangements some level of comfort that it was okay, that it complied with Section 8 of RESPA, which is an anti-kickback provision. It says you can't pay anything of value for a referral. And there's, in that statute, there's a safe harbor that says you are allowed to buy services at market value. So this was a very popular way of doing business, especially for people like title companies that, they do benefit from having a realtor market their services, and they get clients that way. The CFPB came in, and their view of the world is different, perhaps, than HUD's. They really view this as, unless proven otherwise, a sham arrangement. The way that they have read these rules, a marketing services agreement, especially between someone like a title company and a lender, is you're not paying someone to market your services, you're paying someone to refer you business. And what was interesting with Lighthouse Title that started this whole discussion was this theory that even if you're giving a real contract for real services rendered, it can be considered a, quote, kickback because a contract is a thing of value. That's really spiraled since then. There's been a lot of pushback from the industry. There's been a lot of confusion over what can be done to stay within the safe harbor. A lot of best practices have developed, the most popular one being to get evaluation done for the services and make sure you can actually explain that these are real marketing services, not just pay for referrals, to limit payments based on volume and make it based on services rendered and so on. There's also but the CFPB remained active on the enforcement front. There's other cases where they even blended UDAP and RESPA, and there's a lot of clamoring for formal guidance, something along the lines of a rulemaking from the agency. Well, what the CFPB did instead was they wrote a memo which Allison and I have talked about, and I think it highlights the fact that there's competing interests at the agency. There's an Office of Regulations and there's an Enforcement Office. The Office of Regulations is in the business of writing rules that people can follow who want to be compliant. The Enforcement Office is in the business of enforcing. And
Andy, in 2016, is the fight going to be on whether or not one can do an MSA going forward? There's a lot of buzz. A lot of companies have abandoned MSAs, irrespective of whether or not they think they have a good argument that they're legal. But it seems like a lot of the fight is going to be on enforcement related to past MSAs. Is that right?
That's right, and not everyone has abandoned MSAs. An important thing to note about the CFPB's guidance, they didn't say MSAs are per se violative of Section 8. They said they're skeptical of them, and they said that evaluation alone doesn't solve all of your problems. It still could be considered a kickback. But they also implied at least that it's possible for an MSA to comply with RESPA. And I know that there's been some investigations or examinations that have happened where MSAs are at issue and they didn't pursue enforcement actions. So it does come down to the facts, and it comes down to individual facts, as every RESPA case does. It really depends on how diligent you are in making sure your MSA is defensible. Another option being to not use them anymore, but it could be either. And they will be a focus of examinations moving forward. The Bureau's made that very clear.
So in 2016, there's a couple other important issues and enforcement supervision matters related to mortgage that are expected, some of which are already in progress. The loan originator rule affects a good portion of the marketplace. Andy, quickly for folks that are not in the mortgage space, what is it?
Well, the loan originator rule basically says you can't pay a loan originator. And the tricky thing is loan originator is a term of art. It's not defined based on job title or description or anything like that. It's defined based on your conduct. So really anyone who works at a lending operation or for a broker can be considered a loan originator. There's restrictions on how they can be paid. They can't be paid based on transaction terms. And they also have to be, if you are a loan originator, you have to be either licensed under the SAFE Act and the corresponding state requirements, or certified under an alternative that the CFPB prescribed in the loan originator rule if you're not covered under the SAFE Act.
And this is a big issue for folks that are sort of right on the line or doing advertising and marketing brokerage activity or something less, where that line is between loan originator and being a advertiser or marketer in a passive sense.
Sure.
It's something that the Bureau is going to be looking at.
It will be something that they look at. In examinations, it will probably focus more on people in financial institutions who might be doing things that they're not classified as loan originators, they're not certified as loan originators, but they're stepping over the line in some way. They're doing something with a loan application, or they're getting paid in some way that makes them a loan originator. The CFPB has noticed that in their examinations. Calvin Hagens recently at MBA Annual mentioned that they'll be focusing on the loan originator rule, and they've also seen what they've basically dubbed as evasion schemes for the compensation prohibitions for people who are clearly loan originators, where there's been affiliate companies who are basically where certain loan officers are paid to affiliate companies who are taking interest rate-based profits and then funneling them back. They've seen those, and they'll focus on them moving forward. They'll also, of course, focus on all the rules that you've been having to comply with, ATR/QM, servicing, mortgage marketing. I think will be something that they focus on as well. There's been some activity, some studies about reverse mortgage marketing. And back to MSAs, remember that the PHH mortgage decision is now before the D.C. Circuit. That's something that will be decided. It may add some clarity to the RESPA issues that are on the table.
And it may add some clarity or at least amplify issues related to statute of limitations and the ability for the CFPB to bring claims for that period of time that predates either Cordray or the CFPB's existence altogether.
It's a huge issue. You're absolutely right, Jonathan and Andy. It's Allison Baker, for retroactivity arguments, that is, the CFPB bringing UDAP cases or even RESPA cases for conduct that predates July 21st, 2011, which is the date the CFPB came into existence. It's also a big issue for statute of limitations issues, and it also, I think, from a larger policy perspective, raises the question of how bound is the CFPB to prior agencies' use of interpretation guidance of the consumer financial laws that the Bureau now is responsible for enforcing.
And they don't seem to think they're bound at all.
Well, I think if you read the opinion from the Bureau and the ALJ's opinion, but then the opinion from the Bureau, I think that that's a fair read of that, yeah.
Agreed.
And Alex, you see that in supervision and investigations all the time.
Absolutely. I mean, the CFPB seems to be operating from its own playbook, and unfortunately, the issue is that it's only 4 years in the scheme of things, and it hasn't kind of demonstrated a clear, predictable pattern for how it's going to treat a specific finding in an exam from one context to the other. I mean, Andy mentioned everything is fact-specific, but we've come pretty close to seeing the same facts, 2 different examinations, very different outcomes.
It's really, in some cases, it depends sort of what outcome they want, not necessarily for that exam, but for wherever they might be overall with respect to that marketplace or moving the needle in the direction that they want.
Sure. Yeah, they make an example out of someone, absolutely.
Well, Andy, we talked a little bit about HMDA earlier, and just to go back to that for a moment, there's a lot of issues with the HMDA implementation that's expected for folks in the mortgage area that are impacted by this. Is the CFPB just sort of creating a routine cycle of internal overhaul at every mortgage company?
Well, they certainly have been. The TILA-RESPA disclosures alone were, I think in terms of business requirements, 4 times all of the Title 14 rules. HMDA won't be that big, but what HMDA really does is, it is done under a statutory mandate. It's Regulation C, which implements HMDA. It's a new reporting regime. There's new coverage, new transactions that are covered. There's new institutional coverage. There are new exemption thresholds. All of these things will have to be teased out and programmed. Whether you're a lender and you do that in-house, or you're a software service provider and you're developing software for lenders, that will be another big tech build. And then as that unfolds, what we saw with TRID was all of the various issues and problems people will have with the new requirements will be uncovered as they implement. And 2 that I've really just put a finger on, just to throw out there, one is privacy concerns. As you see, the rule expands reporting of sensitive data like credit score and age, but the CFPB basically said that they're going to weigh the potential risk of privacy violations against the need for the data, and that's all they've done to date. How they will handle that issue, I think, will be subject of a lot of contention, a lot of back and forth with the Bureau as we move deeper into the implementation phase. And then ultimately, fair lending, they will be able to see basically your entire loan pricing scheme. They'll be able to look at people, they'll be able to look at how you price loans, and share that with their fair lending office, who we all know is very aggressive. So it's, the long-term implications of HMDA, the long-term concerns are probably even greater than the tech bill itself.
Well, and that's interesting. So the data gathering that's going to happen is either a natural consequence or the CFPB's overreach for data as a consequence of doing the rulemaking here. That could be done in the context of the other rulemakings they've got planned as well. So whether it be in the debt collection market or in the small dollar lending market, you could have a scenario where not only are they going to change the rules on folks, but that they're going to take in more data than they've ever had in order to then execute on supervision, compliance monitoring, and generate more rules.
Well, one saving grace other industries would have is they don't have the Home Mortgage Disclosure Act. So they don't have an actual reporting statute that the Bureau is tasked with implementing. So those would have to be discretionary, but they can, as we've seen with overdraft protection and other products, they can demand data anytime they want and say they're just studying it. They're using it for their academic purposes to inform their rulemakings, and they can get it. So, it's not, there are backdoor ways of them doing the same thing.
And Alex, we've seen already in the lending space generally, in small dollar lending, auto lending, the use of data has influenced the direction that the CFPB is headed, particularly with respect to developing rules to address concerns that lenders are offering either high interest loans or having a lack of disclosure to consumers.
That's right, Jonathan. So the Bureau currently is considering first ever federal rules for small dollar loans, including payday loans, which of course have received a lot of attention from consumer groups, regulators, and state legislators for trapping borrowers in a cycle of reborrowing. in order to pay off the previous loan. So this past spring, the Bureau issued, following a lot of research, data gathering, and kind of the issuance of reports and white papers, a framework for regulating these loans. And although it would not cover all small dollar loans, under the rules, the proposed framework, which would have to then be subject to proposed rulemaking, under the rules, lenders could either assess a borrower's income and expenses, determine their ability to repay the loan, which under the kind of the current framework, it'd be almost impossible to issue a payday loan, or alternatively, comply with a set of requirements with respect to kind of specific loan terms. For example, for loans that have a shorter than 45-day repayment period, cap would have to be $500, and it'd be limited to 3 rollovers. So kind of very specific term requirements. So that's kind of still underway. The proposed rules are expected in the first quarter of 2016. We'll see if they meet that kind of new deadline. Meanwhile, as the Research Markets and Regulations Division studies the space, contemplates the proposed rules, you have enforcement that continues to bring actions against payday lenders and also service providers to those payday lenders. So, for example, debt collectors that specialize in the collection of payday loans. There was a enforcement action in the fall, and even companies involved in the generation of leads that are used to contact consumers that are interested in payday loans.
And Len, they're going after folks that do payment processing too, right?
Yeah, they've gone after a couple payment processors. We're defending one such case, and in that case, it really gives you sort of an example of the scope of parties that the CFPB is looking at. In the primary litigation, they've sued the debt collector, 2 payment processors, 2 ISOs for one of the independent sales organizations for one of the payment processors, and a company that did phone broadcasting for the debt collector. So sued all of those, and then subsequently they sued the lead generator lead reseller administratively. So I mean, they've gone sort of up and down the chain of people that were involved with this allegedly abusive debt collector. It's very reminiscent of the approach that the FDIC, the FTC, the Department of Justice took, as the payday loans, sort of Operation Choke Point, trying to choke off the ecosystem in which these kinds of companies operate.
And Alex, when we're defending these cases, just like the one that Len described and others that you described, the common refrain that we'll get, and certainly most folks would say in the market is, wait a second, there's no rules yet. They said they're going to write the rules, but they told us what they think the rules might be, but they're still collecting, doing research. They haven't had their comment period yet. Why are they bringing enforcement actions now and not waiting for the rules?
Well, I certainly cannot speak as to why they are doing what they're doing. I mean, I sense frustration possibly that the rules are taking so long, and meanwhile they see, in their mind, there's significant consumer harm happening every single day, especially when you talk about the payday loan space. I mean, they've studied this issue, and so have the consumer groups time and time again, and consistently the same message is coming across that, between the rates, the rollovers to pay the previous loans, that consumers every single day are getting harmed.
Allison, overreach?
I don't know if it's overreach. I think what I would say to answer your question is that the CFPB, I think there's a few animating factors. One, some of their cases have statute of limitations issues, and so they have to bring them. It's just a matter of practicality.
They're running out of time.
They're running out of time. 2, I'm not sure from the mind's eye of the CFPB that the payday lending rule that's pending is going to actually provide much solace, if you will, to the enforcement office. 1, because I think that rule will be challenged in court, and its practical implementation is probably 24 months out from when it gets announced. And also, I think the CFPB is very interested in aggressively enlarging its UDAP jurisdiction and how it conceptualizes that doctrine. And these cases provide kind of rich ground for that. So if I had to speculate, I'd say those are probably the 3 reasons why some of these cases are being prosecuted.
And Jonathan, it's interesting, the FTC has also been active on payday loans, but I think they've been more selective in their cases because I know from conversations with some of the commissioners that at least some of the commissioners feel that payday loans fill a void in the financial system, and I don't think there's really anybody at the CFPB who feels that, payday loans are worthwhile. So I think that's really one of those areas where you see a real difference between the two agencies.
That's a good point. And Len, of course, not all loans that are small dollar are payday loans. Oftentimes there's installment loans. And, there's also the term online lending, which in some cases refers to, installment loans or other types of financial products or services. It's not just payday, of course. And, one of those areas, which again is a broad label, doesn't always mean the same thing for the same people, is marketplace lending, which is really, in some cases, just a delivery method, as well as also an investment tool on the back end. Andrew, increasingly we're seeing other federal agencies get involved in speaking about marketplace lending and online lending generally. The CFPB seems to have selectively started to use the term online lending in some cases to sort of suggest a broader market than just payday or small dollar. Could 2016 be the year that the CFPB starts looking at marketplace?
Yeah, I think that's a good point, and I think it kind of underscores the fact that for a number of years, consumer protection folks were focused on payday lending, but that's really a very kind of narrow kind of product amongst a much bigger industry that involves providing these short-term small dollar loans to consumers. And certainly a lot of that has shifted with technology to new online lending mechanisms that provide a lot of different types of loans. Some of these start to get into kind of peer-to-peer lending. A lot of the term that's used is fintech, financial technology, and these can be huge, very large technology platforms that help bring institutional investors in connection with consumers or small businesses looking for loans. And I think that certainly the CFPB is aware of that. They've done some studies and looked at that in the past. Department of Treasury has also been kind of looking at that industry, as has the SEC coming out with some of their rules. And so I think that, yeah, you're going to start seeing a lot more focus on that, especially as some of these startup companies really start to gain ground and make a big impact in the market.
Yes. So Alex, on auto lending, what's the latest there? And also, too, of course, Andy, you've been doing a lot of work, too, in the fair lending space.
Well, I can talk about the auto lending. The major event in 2015 was a larger participant rule. What that means is the CFPB actually went and determined larger participants that they can go in and directly regulate. As you can see on the slide, that covers about 34 of the largest finance companies out there. So what does that mean? That means these auto finance companies who have never been regulated by a federal regulator before are now suddenly going to be regulated by the CFPB. And the CFPB has they've issued examination procedures. They're, of course, going to look at all the usual suspects in the alphabet soup, TILA, Regulation Z, Regulation M for consumer leasing, as well as FCRA, UDAP, ECOA, and so on. But I think where we'll really see activity is on the fair lending side. That's been the focus of the enforcement actions to date. They really focus on this concept of dealer markups, where a finance company allows a dealer to mark up the loan at their discretion, and dealers can, whether the finance company knows it or not, engage in some sorts of profiling, or at least have been alleged to. There's been a couple of really big enforcement actions in the fair lending space, and I would expect to see more, especially as the CFPB goes in and starts examining and has direct access to all of the data that they normally would need an investigative demand to get.
So, Allison, on the enforcement side and on the policy side too, we're starting to see some pushback on some of these issues, and certainly there's been some public efforts on the part of the trade associations to really get to the bottom of what's happening here. And certainly Congress has weighed in too recently, and certainly members of Congress have been sort of on this issue for a long time. Is auto lending starting to be a stalking horse for other markets?
I don't know if it's a stalking horse, but you're absolutely right in that one of the key policy issues that keeps arising in this ECOA, Equal Credit Opportunity Act, enforcement actions involving non-bank auto finance companies is the use of the data. The integrity of the data, the way that data is analyzed, collected, and reviewed. It's not systematically collected like it is in the Home Mortgage Disclosure Act context. And so there's been a fair amount of colloquy back and forth between industry, trade associations, the CFPB, and others, including some consulting firms and economists, about how good this information is and whether or not it actually can form a basis for an ECOA violation. And I think that that is still and continues to be a big issue in this arena. And even with the larger participant rulemaking, you're going to continue to see that issue percolate because I don't think there's an obvious remedy to it.
And speaking of percolating, something that's been out there for a long time, including actually going back pre-CFPB, is overdraft reform. And then you've now got prepaid accounts too, which is something that, Andrew, it's been lingering for a while. 2016, the year for prepaid accounts?
Yeah, so the Bureau for Prepaid Accounts issued an announced notice of proposed rulemaking. They came out with a proposed rule. Comments were due and were submitted in early 2015, and the Bureau is now working to finalize its prepaid rule, which is expected, in spring of 2016. We'll see if that does happen or not. Just briefly to give you a summary of what the rule was proposing. Prepaid cards, which are in a lot of ways kind of like debit cards, where you can load money onto them, you can buy them at stores, grocery stores, etc., and are used by a lot of different consumers for a lot of different reasons. They had not been subject to a lot of direct regulation in the past. Payroll cards, had received some. And so what the Bureau sought to do in this rulemaking really was to take a lot of the existing regulations that applied to debit cards or also applied to credit cards where credit is involved and apply those to these prepaid cards. So some of the requirements, for example, are providing access to account information, making sure consumers have error resolution rights, et cetera.
Sounds like Reg E.
Yeah, that's exactly right. For those of you who have worked with checking accounts and things like that before, it'll be familiar. A big part of it also were know before you owe disclosures, a term that Andy used earlier in the presentation when talking about the TILA. And that's really an area that the CFPB has focused on across all sorts of different industries, making sure that consumers really understand what they're getting into when they seek to sign up and use a financial service.
Andrew, when we talk about, it's called prepaid card. Is it always, it's not always a card, right? That's
no,
a metaphor.
That's right. And in fact, the rule, if I recall, used prepaid account as a term. And looking over, there were 6,000 plus comments that were submitted to this rulemaking. And if you look at a lot of the comments that were submitted by a lot of the big trade associations or individually by banks and other prepaid card type providers, one of the big concerns was that this is a market that has seen a lot of innovation in terms of coming up with new products and services. And there's a lot of products and services that don't really seem to fit into that prepaid category that might get swept into this rule, and there's a lot of concern about that. Those are products like digital wallets, virtual currencies, P2P type services, things that you don't really think of as prepaid but might get swept up into the rule. And so it'll be interesting to see how the Bureau comes out in trying to balance the value that is provided by innovation versus wanting to make sure that consumer protections are built into these products.
Mm-hmm. And then overdraft protection, again, something that's been in the works for a while. CFPB picked up where others left off. What's the latest there?
Right, just by way of background, in 2010, the bank regulators issued new rules requiring banks to obtain consumer consent before being able to charging fees for allowing consumers to overdraft on ATM or debit transactions. These protections that the banks would put forward would not cover other types of ACH payments, just checks or recurring payments. And therefore, if the consumer had overdrawn based on that type of payment, it would result in an NSF fee or overdraft fees, regardless of whether the consumer opted in or not. Fast forward a few years, the CFPB has been kind of studying this issue. In 2013, it submitted a white paper followed by a report in 2014 that analyzed both the outcomes of consumers that opted into this program for overdraft coverage and the underlying transactions that resulted in consumers overdrawing their accounts. And the report found several things, including one that overdrafts and NSF fees represent more than half of all the fee income banks were receiving on checking accounts. and that a very small minority of consumers, about 8% of the accounts, were incurring the vast majority of the fees. This resulted in the CFPB wanting to come up with its own rulemaking to cover this area. It's one of its top regulatory priorities in 2016, and it's in the process of proposing new rules. And areas it's expected to cover are, the opt-in process, exactly how that's supposed to unfold, overdraft coverage limits, transaction posting orders, and things like involuntary account closures.
What's interesting here, too, is Alex, all those items that you just mentioned, including the opt-in process, could have precedent for other markets where you have to do an opt-in. The other products and services use those sorts of devices all the time. You could have carryover here. But you also have, too, this has been an area where there have been investigations. We know that firsthand, and some of which have been finalized publicly. But also, this is definitely an area where a lot of the market has shifted their business practices already. And you've got now a scenario where CFPB has been looking at these past acts and practices, looking backwards, and is going to have to make a decision as to whether or not they want to just look forward or also possibly bring enforcement related to the expectations that are now in their proposal. So we've talked a lot about individual markets. We haven't covered every possible market out there. Certainly some of the loan products that we didn't talk about, like student lending, is a hot area right now, and all the different areas related to student loans, including the advertising and marketing of education generally, is something that the CFPB is certainly taking the lead on with others, even though it's not necessarily directly a consumer financial product or service. But there's also these cross-cutting issues that happen in the life cycle of credit and debt, one of which, of course, is debt collection. And as referenced early, debt collection is the leading complaint gatherer at both the CFPB and the FTC year after year. Many companies in the consumer financial products and services space do some of their own collection activity. And then, of course, there's third-party collection and debt buying. This is an area that the CFPB has been focused on since the beginning, and in 2015 had a lot of watershed moments, and 2016 looks like a big year too. So, Alex, in terms of big issues, the CFPB in 2015 really attacked the basis to collect debt.
That's right. The second half of 2015, we saw a flurry of enforcement actions that very likely will reshape the debt collection industry forever until the rules are settled. But again, this is a really long-lasting implication. So first in July, Chase Bank settled with the CFPB and about 47 states in connection with its debt collection litigation practices and debt sale practices. One of the more kind of consequential claims in that in the CFPB allegations is that by selling to third-party debt buyers, by selling purportedly inaccurate or incomplete, debt with the relevant information to third parties, Chase is assisting debt buyers in deceptively collecting debt. So you're seeing the CFPB, holding a party when it sold its receivables and it's still accountable for what happens to those accounts downstream. Then several months later, the nation's two largest debt buyers settled with the Bureau. And then last month, we saw a law firm that sees many creditors, debt collectors, to sue debtors also settled. And in all of these settlements, we see several common threads. According to the CFPB, all the parties in this ecosystem, from the original creditors that had the initial relationship with consumers and then sold the charge-off debts, to the firms that buy the receivables and then step into the creditor's shoes for collection purposes, to third-party service providers, such as, in this case, a law firm, which in and of itself has a whole host of issues to consider when we talk about regulating the practice of law, as CFPB seems to have tried to be doing with that case. CFPB thinks that all of these parties have essentially been failing to take the steps necessary to ensure that collections are geared toward the correct people for the correct amount. And so to kind of attack that issue, all of these settlements had similar prospective conduct requirements relating to, one, the type of data and account documentation that's required at various points in the collection process in order to form the collector or owner's basis for making collection communications. So in other words, have a basis to collect, being able to even pick up the phone and contact the consumer and say, you owe X. The CFPB has now imposed kind of a heightened standard, according to many, as to what is required to make those types of representations. And the CFPB has ratcheted it up from there. So for debt collection litigation, which was really the focus of the Chase settlement and of course the Hannah Law Firm settlement, an even higher standard for what is required to have on hand before steps can be made either to inform the consumer of the potential for litigation and also what should be included in filings with the court. So, how affidavits, the representations in affidavits were a really high focus in all of these cases. And so you're seeing a kind of a shift in the standard and really picking up where the FTC left off a few years ago. We started to see reasonable basis and substantiation to collect debt in some of the FTC orders in 2007, 8, 9. But the CFPB has really taken the ball across the line here.
And those are issues that obviously impact debt buyers and collectors directly, but also they impact lenders too. When structuring loan products and systems of record, documentation practices, et cetera, all of that becomes extremely important when one considers that they may want to be in a position in the future to be able to sell that debt on the back end if there's a charge-off situation. And then, of course, there's a suggestion, too, through unfair, deceptive, abusive acts or practices authority that the CFPB has, that first-party collectors just generally are responsible for the same, essentially the same requirements, meeting the same expectations as third-party collectors. Usually documentation is not an issue for a first-party collector, but not always out of the woods on that. But Alex, UDAP authority has been a big issue for CFPB in terms of exercising and moving the needle in debt collection. What's the latest there?
So, increasingly, the CFPB has been very, I would say, creative in how it uses its deception authority and the kind of standard for deception in the debt collection space. And if you read all these orders that the CFPB entered into with the four parties I described earlier, the core allegations that consumers were deceived. In other words, that when the representation to them about what they owed, that they owed something and how much they owed, that those statements were deceptive without the party having certain backup or support to make that representation. So saying that a consumer owed X number of dollars in the debt collector is not substantiated unless the debt collector was able to review the original account level documentation saying that X number of dollars was owed. And so this is taking a deception standard, which has always existed in the FDCPA, of course, and has always kind of applied to, you can't use false statements to collect debt. You can't tell a consumer that they're going to be sued if there's no intention to actually bring a lawsuit. That needle has really moved now, where you're having anything that can, say to the consumer about what they may happen is all going to be, implicit. Every representation made to the consumer has to be considered from, all possible reasonable interpretations, including, for example, the statute of limitations is an affirmative defense against a lawsuit. And, after a lot of case law in this area, it kind of became settled law that a debt collector cannot bring a lawsuit against a consumer if the account is past the statute of limitations. That had become kind of the new standard. It's now gone to the point where if the debt collector does not disclose to a consumer that his account is past statute of limitations, it's arguably deceptive to even engage in collection. So the slippery slope is, it's certainly in play here.
And there's been a number of recent enforcement actions, and as you mentioned earlier, some of these are not purely debt collection actions. They may be against small dollar lenders or others. Len, you certainly have seen this firsthand when you were at the FTC, but you're also seeing it play out now with some of our clients and in our work defending folks. From your perspective, how do you view debt collection in 2016?
You know, when you read the papers that the CFPB submitted in the Universal Debt and Payment Solutions case where our client Global Payment got sued, you would think that debt collection is an illegal activity. And I mean, literally, when you read their motion, their opposition to our motion to dismiss, and even parts of the complaint, you would think that it is an illegal activity. And I think the CFPB is so suspicious of every step along the way of the original lenders and of the buyers and of the collectors, and there is just an inherent suspicion that all of them are, sort of taking shortcuts or deliberately trying to screw consumers. And I think the industry probably needs to do some more to try and educate that. And I think this is one of those other instances where at the FTC, when sort of those substantiation standards were being debated, there was a lot of talk about the cost of how much burden on the system could the system hold and still function efficiently. And my sense is that those sort of cost-benefit analyses are really missing at the CFPB.
No, it's always whatever is better for the consumer, not the marketplace as a whole. And cost of credit doesn't seem to be a concern.
One issue that I see keep coming up in the CFPB enforcement actions, and I thought it was curious that they also made the two top complaint getters, if you will, are credit furnishing and debt collection. And what's interesting about both of those from the CFPB's perspective is that neither of those are services that consumers actively select in the marketplace. And some of what animates the CFPB's enforcement agenda is conduct that arises from products or services that consumers do not select, such as mortgage servicing, student loan servicing, debt collection, credit furnishing. And I think that that's important to keep in mind as we continue to see these trends emerge and we continue to kind of scratch our heads and say, what's going on over there? That's some of what the thinking is. I think that does inform their enforcement agenda and probably their supervision agenda, frankly, to some extent as well.
It also, though, exposes the Bureau, in some cases, to litigation risk. There's not always the legal authority here to be taking the positions that they've been taking and sometimes extracting in settlements. And so the important sort of decision-making calculus for anyone in-house and as well as counsel representing companies is has the Bureau gone too far with their sort of outcome precautionary principle-based approach to regulating the marketplace?
One area you're seeing that, I mean, you read the Chase order and it actually has prohibitions on what Chase can sell to, and when it does sell it, there are requirements as to what the contracts between Chase and the buyer have to include. So you have the CFPB regulating contract between private parties for the sale of their own receivables. So, I mean, it's really in terms of, I've never seen anything like that, and it's really having repercussions in the entire market because everyone's nervous now to even engage in debt sales.
Yeah, without really good guidance and really the rulemaking too should, in theory, be where a lot of this is addressed. Alex, what's the latest on the debt collection rulemaking?
So the advance notice of proposed rulemaking was issued in November 2013. We're still waiting for the notice of proposed rulemaking. I didn't even see it on the Bureau's list of things it's supposed to be doing this coming year. It wasn't in the annual report that it just issued. Even if they get as far as issuing the proposed rules in 2016, the final rules, the earliest that would come online is 2017, and who knows if there's going to be implementation periods built into the rules. I expect that there will be, given the vast scope of the topics that the rulemaking likely will address. I mean, the advance notice covered pretty much every single aspect of debt collections, from debt sales, documentation, communications technology, etc. So again, it's been very frustrating for a lot of companies in this space because, again, in the absence of the rulemaking, this vacuum, you see a lot of enforcement that has, in the minds of most entities in this space, taken where the law was, and this is not a new area. I mean, the FDCPA has existed since the 70s, and moved it, and the goals seem to always be moving. So in the meantime, all companies can do, and it's not just debt collectors, but first, creditors, is kind of follow the guidelines, the guidance bulletins, and enforcement actions to get some sense of what the Bureau expects.
Yeah, and I mean, that's a good point, too, in terms of looking at the compliance bulletins that are issued periodically as kind of foreshadowing where the Bureau may be going. And in 2015, the Bureau released a compliance bulletin on in-person collection of debts. And I think what's interesting about that was not so much the topic, but looking towards the rulemaking, is the fact that they talked very clearly about first-party collection as well under UDAP principles, as well as third-party under FDCPA, kind of seemingly to suggest that the overlap between the UDAP does kind of cover FDCPA-type issues, so that first-party creditors should be keeping an eye on that when the debt collection is making.
UDAP really gobbles up everything. The CFPB is not afraid to use UDAP to fill the authority vacuum.
And the rumor within the agency as to why there's delays in the rulemaking is that they're toying with the idea of developing disclosures, and they've been doing consumer testing of certain disclosures. What those will actually look like, I couldn't tell you, but that's part of what they're doing. That's consistent with what they've done in other rulemakings. The consumer testing process can be long and rigorous, and remember, they do consumer testing but not industry testing. So if they develop disclosures, they're going to be designed to be as helpful to consumers as possible, regardless of the burden they may impose on those who have to use.
Well, and Andy, that raises a good point. For folks that follow regulatory announcements, the big ones are easy to find, but it turns out that there's a slew that go through the Office of Management and Budget for information gathering, and in some cases, surveys and disclosure testing that happens out there in the marketplace. It's not stealth, but it does not get a lot of publicity at all. And that's something that industry definitely needs to be mindful of, because that stuff can happen, and a lot of it can be cooked before it even becomes publicly announced in the context of that rulemaking. For more on the rulemaking, as well as many other topics that we've covered today, there's plenty on our website at venable.com/CFPB. On the slides that folks will be receiving after today's presentation, some of these pictures are actually hyperlinks, and so you can click on them and go directly to additional information about these topics, including the debt collection rulemaking and the small business review process, which really gives us the best indication of what that timeline will be once they actually do that. And this, for folks that don't know, the small business review process is something that's statutorily in the CFPB's authority under Dodd-Frank, where they have to kick over proposals to these small business review panels before they can then issue the advance notice. Now, what is interesting about those review panels is they're not run by the CFPB, and there are limited slots, essentially, each year in each quarter. And so small dollar lending got a slot, arbitration got a slot, and so the question becomes sort of where's debt collect? There's a slot for debt collection. And that helps folks understand what the timeline will be, and certainly no shortage of questions that we receive here at Venable on that topic. So shifting gears, credit report and data furnishing, a cross-cutting issue. Andrew, what's going on in that area?
Well, I guess the place to start would be December 2014. CFPB announced it's requiring major CRAs, and there's only a handful of very large CRAs, to provide regular accuracy reports as part of ongoing examinations. We've got kind of a sample that the Bureau came up with there on the screen that you can take a look at. The reports will highlight key risk areas for consumers, including disputes that are filed by furnishers with the CRAs. The CFPB expects a CRA, when they are doing this, to investigate, identify if there's a problem, and take appropriate action if a furnisher has kind of an outsized number of disputes. This really fits in with the CFPB being kind of a data-driven agency and bringing that perspective to things, to actually looking at the information that you receive as a CRA and kind of analyzing it to use in your day-to-day operations.
And this is part and parcel with the CFPB's kind of priority from day one to hold every party in kind of the credit reporting system accountable for the accuracy of the information. After debt collection, inaccuracies in consumers' credit reports is the highest, source of complaints to the CFPB. And the CFPB takes kind of furnishers' responsibilities very seriously. It has kind of supervision authority over the credit reporting agencies, but also, increasingly looking at the furnishers. And this initiative to get data from the credit bureaus about furnishers to see, which furnishers have the highest disputes, and kind of asking the CRAs to take a more active role policing the furnishers is, kind of, again, having everyone looking at each other to make sure that there's self-policing going on in this area. And turning to the next slide, Jonathan, again, the last kind of few months the CFPB, again, spotlight on the furnishers. The fall 2015 supervisory highlights, which kind of compiles all the CFPB's observations during examinations on an anonymous basis, observed furnishers' failures. This is the first time I think that the supervisory highlights had a focus on what furnishers were doing. And they identified various issues. One, some furnishers failed to establish policies as required by the rules. Furnishers are failing to review and update their policies. And this is really important because the Fair Credit Reporting Act and the Furniture Rule, it's not new. It's been around for more or less the same for many years. And a lot of companies kind of haven't re-examined how they credit report since they've had to update to Metro 2.
And just to take a step back, Alex, for particularly folks in the debt collection space, but whether or not but furnishers generally, Metro 2, an enhanced EOSCR means images. And so if you're not reviewing the images, therein lies the issue with the furniture rule. Is that right?
Well, there's so many issues with the furniture rule. It's not just having the policies and procedures and systems. A lot of this is driven by business rules. It's all technologically driven. You have, a transaction that triggers something in the reporting, and if they're not connected correctly or the pipelines aren't talking to each other correctly, you're not going to have correct reporting. But on the back end, there's dealing with disputes. So furnishers have, dual obligations under the FCRA and the furniture rule. It's not just what they feed into the system, but when they get a dispute, how they handle the dispute. They have very specific requirements. And, you've seen enforcement actions that the Bureau brought for what I would consider pretty technical requirements. You had 30 days to respond to a dispute. There was a company that wasn't, able to meet the 30-day deadline. They brought an enforcement action and requiring restitution to 13,000 consumers for the failure to respond to the dispute within the 30-day time frame. The company was responding, just not within the 30-day time frame. So you're seeing a combination of the CFPB looking at the hyper-technical compliance with the rules, but also like a high-level kind of, is the system working in a way to ensure the highest level of accuracy in consumer reports?
Yeah, and the revamp of systems, policies, and procedures in light of the enhanced EOSCR is something that the Bureau has put out bulletins on. Certainly in supervisory and in examination context, it's been very ripe. And then in some cases, in some settlements and enforcement actions.
And what's interesting about this is the CFPB has even gone after companies that are pretty far afield and really not within the scope of what we would call consumer finance.
That's right.
Yep.
That's right. And there's also the dual jurisdiction issue where you've got the FTC that's out there as well, both in the collection space and in credit reporting, still very relevant, not necessarily setting as much precedent with bulletins and advisories as the Bureau, but very much out there as well in policing and enforcing. And so even if you're not covered by the CFPB, the CFPB's announcements in this area become very relevant because the FTC could pick it right up. So for more on data furnishing, there's plenty on Venable.com, including a webinar from a few months ago, as well as several articles that connect this topic, both the debt collection and debt buying, as well as also just general furnishing obligations. It's something that we're seeing in examinations over and over again, and it's one of those things that virtually all companies in the consumer financial space have some role in, whether it be even as a furnisher or just simply as someone who's using credit reports. Of course, you'll be able to click on those for links directly to those. So another topic, and Andrew Biggert, something you've been working on a lot lately, payments. And payments is a broad term, but really recurring payments, continuity programs, whether they be loans or others, usually involve some sort of debiting of the consumer's account on an automatic basis. May or may not trigger Reg E, but certainly something that the CFPB has been interested in.
Yeah, it's like a lot of these areas, it's an area that cuts across a lot of different industries, and it can affect collections, it can affect merchants, and the main rules that we're looking at here are Regulation E, which implements the Electronic Funds Transfer Act, and then some of the rules for like NACHA, for example, which manages the ACH network. But you mentioned, Jonathan, that one of the issues is setting up recurring payment plans. This is something you might see a merchant doing, but also in the collection industry, for example, that can be a common way to set up a payment plan. And that kind of a process is regulated by Reg E. It requires certain authorizations to be obtained from the consumer in order to set that up, certain disclosures to be made to the consumer. And the Bureau has very recently issued CFPB guidance that basically really summarizes and explains what the Reg E requirements are. Of particular note, the Bureau explained that in at least one supervision they found that obtaining consumer authorization to set up a recurring payment plan could be done over the phone with a verbal authorization.
Which is a big move for the Bureau to admit.
Well, that's an issue that had been, there's been a lot of confusion kind of in the industry about where Reg E kind of intersects with the Electronic Signatures Act and whether or not you actually had to get some kind of a electronic signal or some kind of a writing versus just a verbal authorization.
You may be even very generous that there may have been confusion within the Bureau, too.
Well, I mean, potentially, but it was interesting to see that this was a case where they came out with what you might call the less aggressive position by saying that a verbal authorization might suffice. So it'll be interesting to see how industry reacts to that, whether they stay taking a more conservative approach where maybe you have the consumer push a button on their phone to indicate that they're authorizing a payment plan versus actually just obtaining the verbal authorization.
Yeah. Well, I think what's important here, too, is this guidance is as much for folks within the Bureau as it is outside the Bureau. Because this was one that kept coming up in examinations over and over again where line examiners seemed baffled by the fact that payment was taken by phone. So another item that's cross-cutting, something that's been already announced in terms of what the proposal is going to be and is likely teed up for a real official announcement in terms of rulemaking, and probably in the first quarter, is conventional wisdom, maybe even any week now, is arbitration. CFPB under Dodd-Frank has the ability to essentially ban arbitration provisions in consumer financial products and service contracts. Raises some issues for a number of folks prospectively, because it's not technically a retroactive law, but it really hits folks with continuity programs. You do a contract one day, maybe the CFPB bans it and it takes effect, halfway through your installment loan contract. It's going to be interesting to see how that plays out. But Andy, what's this all about, though? What is the ban on arbitration?
Well, it actually, this is a good example of something that was influenced by those initial Dodd-Frank rulemakings on the mortgage space. One of the Dodd-Frank amendments banned mandatory arbitration clauses in mortgages. That was done a couple of years ago through the Dodd-Frank mortgage rules. They started studying mandatory arbitration clauses for other financial products, particularly credit cards. And I think it's especially important in light of the Concepcion case, Concepcion versus AT&T, which is from 2011, where the Supreme Court said an arbitration clause with a class action waiver was enforceable and actually could eliminate consumers' rights to litigate through a class action, to join a class. That, all but killed class actions in this space for the last couple of years. And the Bureau started studying the consequences of that. One of the things that they've really focused on was, whether or not that really impedes what are called private attorneys general, plaintiffs' class action lawyers, from going out and filing class action suits over, what essentially are minuscule damages on an individual basis. For example, you're charged a $5 fee that may not be permitted. Most people would not find it worth their while to actually go and arbitrate over that fee or even know that they were charged it.
But you might go to the consumer complaint portal and
Right.
see if
Might go
you
to
could
the
adjudicate it, right?
But this actually allows private attorneys to go out and affect policy. So that's what's driving the study. You know, they've gone and conducted a thorough study. Depends on who you ask as to how thorough it was. But there's a study that focused heavily on credit cards. Now they're exploring the idea of at least banning class action waivers and mandatory arbitration clauses, which would be a big deal to everyone. Basically everyone but mortgages where they're already banned. And this can come up with installment lending. It can come up with credit cards. It can come up really with any sort of financial product. And one of the interesting questions I've heard is, if you have something like installment sales where you're selling a device but you're financing it through an installment contract, can the CFPB ban your class action waiver for all things, or does it only have to relate to the financial regulations that you're subject to? Those are all questions that I think will be addressed through the rulemaking, but it has a massive potential impact for really every industry.
Yeah, I think it's really going to change the internal risk calculus too, in terms of compliance versus any business or legal risk the company may be willing to take, just simply because it's not going to have the ability to, if it takes effect, and there's presumably probably likely some legal challenges and litigation that's going to ensue, but ultimately the calculus in terms of, okay, we have this contract and we know we're going to be able to arbitrate, that goes away and changes that for in-house counsel and advising on risk. It's going to be a different dynamic.
Well, it makes the cost of a class action part of your risk calculus, and I used to do class action litigation in a former life. I've seen nationwide class actions where the damages were in the billions. And that's something everyone who operates in this space will have to think about as they move forward, assuming that this rulemaking happens as scheduled and as planned and as challenged and everything else.
Yeah, which all those are definite possibilities.
I think the arbitration rulemaking is the single biggest thing that the CFPB has done since it came online. I think the potential for impact in not only the consumer finance industry, but other consumer-facing industries writ large is tremendous.
And certainly could have a lasting impact even well after, even if there's any reforms to the CFPB at all.
Absolutely.
Unless there was let's say this takes effect and there's no rollback or anything of this particular provision, it's certainly going to enhance the private plaintiffs and the bounties that can be placed on technical noncompliance with the law.
Sure.
And I think, if you talk about companies and industries that you think of as maybe historically not being consumer finance industries, but are increasingly consumer finance businesses, and they revamp an agreement with a consumer, that company starts readjusting its risk and probably rewriting contracts and all of the other different, facets and sectors of the economy where they offer products and services. And so it bleeds into everything. And I think it's really a huge initiative on the part of the Bureau.
It could really stifle innovation too. So on enforcement and examination trends, there's certainly no shortage of enforcement activity. We've touched on a lot of it, including there's an article today in the Wall Street Journal talks about how the CFPB doubled essentially its enforcement actions in fiscal year 2015 as compared to the prior year, taking in a lot of money, some of which is going into the civil money penalty fund and being paid out in some cases when there's non-compensable refunds or a restitution of disgorgement that the CFPB is looking for in settlements. But there's some bigger picture trends as well. And on that, really there's really two buckets. There's sort of this idea that the CFPB is doing more cooperation with, and we're seeing more cooperation publicly with various enforcement agencies. But we're also seeing the CFPB tackle alleged violations of the law through means that are not necessarily direct to just the companies at hand, but also service providers, related persons, and using novel theories related to UDAP, such as, for instance, the lack of state law compliance. Allison, you're nodding your head. Overreach?
I don't know if I want to say overreach, but it's definitely an aggressive and expansive view of the CFPB's enforcement jurisdiction and its UDAP, jurisdiction as well. You talk about the cash call case, the judgment on the pleadings decision that just came out of the district court in California.
Which brings in state law compliance.
Absolutely. It brings in state law compliance. The allegations in that complaint are that the company engaged in violations of the Bureau's unfair, deceptive, or abusive acts or practices prohibition by virtue of offering loans that violated various state law usury laws, which is a very novel concept, arguably federalizing state law. That was certainly an argument that was made. The court didn't per se reject that. It simply denied a motion on the pleadings, which is a little bit of judgment on the pleadings, which is a little bit different than simply dismissing that argument out of hand. But it's very aggressive, certainly intended to be an expansive view of the CFPB's enforcement jurisdiction, its UDAP authority. I similarly see that with its theories of substantial assistance in a number of matters. It's also using its related person jurisdiction very aggressively, and for those on the phone who aren't exactly certain as to what that is, essentially bringing individuals into matters by virtue of the fact that those individuals are principals of companies that are the subject of a potential or actual enforcement action. And that's a pretty aggressive use of that as well. It's almost in some ways unprecedented in the enforcement world. And I'm curious as to what Len thinks, given his experience with the Federal Trade Commission.
Yeah, I think one of the interesting things that's to watch going forward is going to be, especially on the unfairness. One of the elements of unfairness at the FTC is that the cost, essentially, of the remedy can't outweigh the harm to consumers. It's almost like an analysis you would take for a rulemaking, because when Congress sort of imposed that, they realized that otherwise the FTC essentially would be playing tennis without a net. Anything's unfair, and that's sort of the impetus for that, because the FTC in fact was doing that. It'll be curious to see in litigation how courts interpret that and what sort of level of proof the courts hold the CFPB to, because that's part of their burden essentially, is to show that the consumer harm is grossly outweighed by the costs of the remedy that they seek to impose. And in some of these cases, I don't think that's nearly as easy. And then obviously all the elements of the substantial assistance are getting litigated. The initial decisions on what the knowledge component and the level of assistance are, in our case, the motion to dismiss was denied, but the court set a very high level. So I think a lot of these issues are going to be in play. It'll be curious to see if the CFPB gets its nose bloodied a few times, whether they proceed a little bit more cautiously. My inclination is they probably won't, but we'll see.
No, but they certainly need to, right?
Yeah.
So on examination trends, certainly exams can lead to enforcement. We're seeing that over and over again. We're also seeing, too, in some cases, hundreds of millions of dollars being returned to consumers as a result of examination findings that don't necessarily lead to enforcement settlements. And the statistics on that are somewhat staggering. It's almost like the Consumer Complaint Portal. Again, there's, in some cases, an expectation that money should be leaving companies, going back to consumers without just enforcement. Sometimes it's through examination or the complaint portal. But in the examination setting, you're seeing a lot of aggressiveness shifting, in some cases, from areas where there had been some stability or a lack of findings to areas such as payment processing, collections practices, and consumer reporting, as we've already said. And we expect to see more of that in 2016. An ounce of prevention is really worth it on the front end. What we're seeing in exams over and over again is examiners at the Bureau can reach conclusions relatively quickly, and it's hard to ratchet that back. And so for folks that do, quote, exam prep or mock internal work, or even your internal audit teams, for folks that are in the compliance area, all of that's extremely important to find the gaps. But equally as important is that the policies, procedures, and practices be readily understandable and defensible, because if one has to reinterpret later or present that story, it can be challenging. So we're coming up on the close of the webinar. So for folks that have sent in questions that we haven't worked into the conversation, please, by all means, continue to do that through the online system. We'll be following up after today's webinar on that. Quickly, though, to the panel, this is also an election year. That doesn't necessarily mean a change of the CFPB, but it could mean a change in the legal and political environment for the CFPB. Certainly, that's been in the works now for 4 years. Cordray's got 1 year left after the next president, roughly speaking, and really 2 years left as of today. And no signs of him leaving early, and that he probably would stay later if he could. Quickly, Andy, what do you see in election, sort of election year dynamics? Do you see the CFPB adjusting at all, ratcheting up, or playing it safe?
Well, you're talking about going into the election year.
That's right.
I think ratcheting up. One of the things that you'll see is a big push to get these hallmark rulemakings, like the payday rulemaking, done. That's something Rich Cordray is very personally invested in. He really considers that his stake in the ground as the director of the CFPB. I think they will make sure that is finished before the election year. Just not that the election year would necessarily change anything, but just to make sure that it happens. There is always a chance, depending on how things shake out, that the Bureau could move to a commission or something along those lines. I think at this point the Bureau going away is probably more than a long shot, but there could be some changes, and I would expect them to try and get as much of these rulemakings finalized as they can in the next year.
Len?
I think moving this to a commission makes a lot of sense. I think a lot of the and also, well, I don't think it'll be fixed to have it report to Congress. I mean, a lot of the excess that you see is from the lack of having sort of somebody going, is that really a good idea? And at the FTC, you have a bipartisan commission. Historically, the FTC has tried to act in a bipartisan way that ebbs and flows. But I think, having people from different parties sort of having a voice in setting priorities, in setting enforcement strategy, and figuring out where the lines are, is good government. And I think having essentially one person do that is a little scary. And I think some of the things we've talked about today are evidence of that.
Allison?
I'm not sure I think the CFPB itself will change course markedly because of the election year, but what I'm watching is what's going on Capitol Hill. There's been a lot of conversation about trying to make the CFPB into a commission. That's getting some traction, especially in the House Financial Services Committee. I think there's been some conversation as well, although less so, about trying to make the CFPB subject to congressional appropriation. It's currently not. It's funded by the Federal Reserve, which is like all of the other banking agencies. I don't think that will get as much traction, but what I'm watching is this conversation in the House Financial Services Committee about whether the Bureau ultimately becomes a commission or not.
Andrew?
I guess I would maybe take a little bit of a different approach here. Rather than looking at what the next year from an election perspective might add, I think it's interesting to just kind of look internally at the Bureau itself. 4 or so years they've been there. They've now gone through examinations of a couple of different industries. They've learned a lot through those examinations. They've gathered a lot of data and information through the rulemakings and through other outreach efforts. So I think it's going to be interesting to see how they start to use some of that expertise and information they've developed moving forward.
Alex?
Just following up on Andrew's point, with respect to kind of harmonizing how they deal with examinations, I have to say I've been a little frustrated, disappointed that there has not been that much harmonization. But hopefully in the next couple of years they will kind of be able to do that through a combination of kind of just aligning their information and really kind of calibrating how they're assessing facts and coming out with the findings and the outcomes of different examinations. And so I do think that will happen. It just takes time, and it just hasn't happened yet, unfortunately.
Yeah, that's the challenge for industry associations and companies in this space. For 2016, there may be a need for a wait-and-see approach, but also to take a conservative approach. The likelihood is at some point something will give, but the question of when. We're already starting to see Congress bring to light a number of internal policy disagreements within the Bureau. We're starting to see the Bureau, Andy, as you referenced, the Bureau feeling pressured to wrap up certain things in the event of either time it lapses or there's some sort of other change. And then Allison, you mentioned earlier too, in some cases they've got statute of limitations issues, jurisdictional concerns, all sorts of things. So 2016 is going to be a very interesting year in all of these developments, and it's going to be one where I think companies are going to need to be nimble, but also factor all of this into their internal conversations, whether it's product development, risk analysis, from a standpoint of any type of investigation or examination, pushback, and then a whole lot more.
And one thing we can all agree on is they're not going to slow down.
That's for sure. So we're about out of time today. Again, for folks that have sent in questions that we didn't work into the conversation, and many we did, we'll be sure to get back to you directly. We welcome any additional questions after the fact as well. And then stand by, of course, for the CLE code. We'll be providing that in just a moment. So today, first off, we'll be sending out information about our presentation, and if anybody would like a copy or to access the presentation and the recording, it'll be available on our website along with our index of articles and other presentations at www.venable.com/CFPB/publications. The presentations will be available later this week along with the recording. I'd also like to thank our panelists, Len, Andy, Andrew, Allison, and Alex, all members of our CFPB task force for participating, our communications team, including Camille King, and all the others that worked to put this on today. Again, for more information on the topics discussed, please visit our website, /CFPB/publications, and we thank all of you for attending today and making this a good session with a great turnout. You've been listening to Consumer Financial Protection Bureau 2016 Outlook from Venable LLP. Thank you for joining today or listening in on the recording. Have a great afternoon. Thank you.